Welcome to the Consumer Financial Protection Bureau's public field hearing in Newark, New Jersey at Essex County College. At today's field hearing, you will hear from Director Richard Cordray, Deputy Director Steve Antonakis, and a panel of distinguished experts who will discuss pre-dispute arbitration clauses found in contracts for consumer financial products and services. The Consumer Financial Protection Bureau, or the CFPB, is an independent federal agency whose mission is to help consumer finance markets work by making rules more effective, by consistently and fairly enforcing those rules, and by empowering consumers to take more control over their economic lives. My name is Zixta Martinez. I'm the Associate Director for External Affairs at the CFPB. Our audience today includes consumer advocates, industry representatives, practitioners, and of course, consumers. We're delighted that you're here with us today. Let me spend just a few minutes telling you about what you can expect at today's field hearing. First, you'll hear from CFPB Director Cordray, who will provide remarks about the subject of arbitration. Following the director's remarks, Deputy Director Steve Antonakis will frame a panel discussion on the same subject. After the discussion, there will be an opportunity to hear from members of the public. Today's field hearing is being live streamed at consumerfinance.gov, and you can follow CFPB on Twitter and Facebook. So let's get started. I'm now very pleased to introduce Richard Cordray. Prior to his current role as the CFPB's first director, he led the CFPB's Enforcement Office. Before that, he served on the front lines of consumer protection as Ohio's Attorney General. In this role, he recovered more than $2 billion for Ohio's retirees, investors, and business owners, and took major steps to help protect its consumers from fraudulent foreclosures and financial predators. Before serving as Attorney General, he also served as Ohio State Representative, Ohio Treasurer, and Franklin County Treasurer. Director Cordray?
This is the arbitration report. It's pretty significant. Thank you for joining us for this field hearing at the Consumer Financial Protection Bureau. We're here in Newark today to discuss the subject of arbitration. At its most basic level, arbitration is a way to resolve disputes outside of the court system. Parties can agree in their contract that if a dispute arises between them at a later time, rather than take it before a judge and perhaps a jury as part of a public judicial process, they will be required to turn instead to a non-governmental third party, known as an arbitrator, to resolve the dispute in private. These contractual provisions are referred to as pre-dispute arbitration clauses. Arbitration clauses were rarely seen in consumer financial contracts until the last 20 years or so. Arbitration is often described by its supporters as a better alternative to the court system, more convenient, more efficient, and a faster, lower-cost way of resolving disputes. Opponents argue that arbitration clauses deprive consumers of certain legal protections available in court, may not provide a neutral or fair process, and may in fact serve to quash disputes rather than provide an alternative way of resolving them. Long ago, prior to the Great Depression, Congress provided a general framework that located the role of arbitration in federal law. Court decisions over the years refined the relationship between private arbitration and formal judicial proceedings under a number of federal business statutes, including the antitrust laws and the securities laws, as well as under the labor laws. More recently, however, Congress has taken an increased interest in arbitration clauses in consumer financial contracts. In 2007, Congress passed the Military Lending Act, which prohibited such clauses in connection with certain loans made to service members. That was the first occasion on which Congress expressed explicit concern about the effect such clauses may have on the welfare of individual consumers in the financial marketplace. In the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, Congress went further and prohibited the inclusion of arbitration clauses in most residential mortgage contracts. Another measure in that same law is of special interest because it leads directly to our discussion here today. In Section 1028 of the Dodd-Frank Act, Congress directed the Consumer Bureau to conduct a study and provide a report to Congress on the use of pre-dispute arbitration clauses in consumer financial contracts. Further, Congress provided that the Bureau, and I'm quoting the statute, the Bureau, by regulation, may prohibit or impose conditions or limitations on the use of such arbitration clauses in consumer financial contracts if the Bureau finds that such measure is in the public interest and for the protection of consumers, and findings in such a rule are consistent with the study performed by the Bureau. That, again, is the study we're talking about here today. We've set about this mandatory task to study the use of arbitration clauses with conscious care. We began our study almost 3 years ago when we issued a request for information seeking public input on the appropriate scope, methods, and data sources for this work. We received dozens of written comments in response and held a series of stakeholder meetings to gather more informal input. In December 2013, we released preliminary results from our study. We wanted then to provide a progress report to the public on our work while also eliciting further comments on the work plan that we had developed. In those results, we found that arbitration clauses are commonly used by large banks in credit card and checking account agreements. We also found that these clauses can be used to prevent any litigation, including class litigation, from moving forward. In addition, we observed that roughly 9 out of 10 such clauses barred arbitrations on behalf of a class of consumers. Today, we're releasing the results of our study, and we're providing our arbitration report to Congress as the law requires us to do. As far as we are aware, this is the most comprehensive empirical study of consumer financial arbitration ever conducted. We looked at over 850 consumer finance agreements to examine the prevalence of arbitration clauses and their terms. We have reviewed the following categories of disputes: over 1,800 consumer finance arbitration disputes filed over a period of 3 years, a sample of the nearly 3,500 individual consumer finance cases we identified that were filed in federal court over the same time frame, and all of the 562 consumer finance class actions we identified that were filed in federal court and in selected state courts. We also looked at over 40,000 small claims filings over the course of a single year. We've supplemented this research by assembling and analyzing a set of more than 400 consumer financial class action settlements in federal courts over a period of 5 years, and more than 1,100 state and federal public enforcement actions in the consumer finance area. We also conducted a national survey of 1,000 credit card consumers to learn more about their knowledge and understanding of arbitration and other dispute resolution mechanisms. Needless to say, simply assembling, let alone analyzing all this information, was a substantial undertaking. But at the Consumer Bureau, we're committed to data-driven decision-making. With limited exceptions, the debate that has taken place over arbitration clauses has not been informed by actual empirical research into the facts on the ground about arbitration generally, or consumer finance arbitration specifically. So we believe this was an investment well worth making, even though the process took longer than it otherwise might have taken. It is not possible in the space of a few minutes to do justice to the depth and richness of the Consumer Bureau's report. But I want to discuss a few key findings that shed light on some of the major questions that have been much debated by various stakeholders. In discussing these findings, it's important to bear in mind that when it comes to consumer finance, arbitration clauses are contained in standard form contracts where the terms are not subject to negotiation. Like the other terms of most contracts for consumer financial products or services, they are essentially take-it-or-leave-it provisions. Consumers may open a new account or procure a new product without being aware of what the contract says or without fully understanding its implications. As part of the study we're releasing today, we looked at arbitration clauses in at least 6 different consumer finance markets. In order to understand the effects of arbitration clauses, we wanted to know how many people use consumer products or services where the standard customer agreements include such clauses. In the credit card market, we found that credit card issuers representing more than half of credit card debt have arbitration clauses. In the checking account market, we found that banks representing almost half of insured deposits have arbitration clauses. Given the size of these markets, we can safely say that tens of millions of consumers are covered by one or more such arbitration clauses. Indeed, for credit card accounts alone, the number could be as high as 80 million consumers. Sometimes consumers are given a one-time chance to opt out of these clauses, but our research showed that consumers were generally unaware of this. A key question we asked is to what extent individual consumers use arbitration procedures or individual litigation to challenge company behavior that they believe to be wrongful. The answer is not very often. We looked at disputes where an arbitration case is filed with the American Arbitration Association, or AAA, the largest administrator of consumer finance arbitration disputes in the country, between 2010 and 2012. Across 6 consumer finance products markets, covering tens of millions of Americans, just over 1,800 arbitration disputes were filed with the AAA, an average of about 600 per year. And over 20% of these cases may have been filed by companies rather than consumers. Moreover, almost all of these disputes involve matters where more than $1,000 was at stake. That is, in this data, consumers seem to be indicating that it rarely makes sense for them to bring an individual claim with only a small amount at stake. We sought to study what happened in these arbitration cases, but we learned that for the cases filed in 2010 and 2011, approximately 2/3 ended without a decision from the arbitrator, either as the result of a settlement or some other informal resolution. In the cases that were decided, arbitrators awarded consumers a combined total of less than $175,000 in damages and less than $190,000 in debt forbearance. Arbitrators ordered consumers to pay $2.8 million, predominantly on debts that were disputed. We also found that individual consumers are much more likely to bring a lawsuit in a court instead of pursuing a dispute in arbitration. During the same 3-year period, we found nearly 3,500 individual consumer finance lawsuits were filed in federal court in 5 of the 6 consumer finance markets covered by the arbitration data we studied, an average of under 1,200 per year. We studied all of the cases in 4 markets and a random sample of credit card cases and found very few that were resolved by a court. In those that were resolved by a court, consumers won under $1 million, and more than half of that total came from a single case. We also looked to small claims courts, but found little evidence of extensive consumer filings from the limited information available about those proceedings. Instead, small claims courts seem to be used mostly by companies filing debt collection lawsuits against consumers. The survey we conducted reflected these findings. In that survey, we asked consumers what they would do if they were charged a fee by their credit card issuer that they knew to be wrong, and they had already exhausted all possible efforts to obtain relief from the company. Only 2% of consumers said they would consider bringing formal legal proceedings or would consult a lawyer. That is almost the same percentage of consumers who said they would simply accept responsibility for the fee. Most people, in fact, say that they would simply cancel their card. The research thus indicates that consumers are very unlikely, acting alone, to even consider bringing formal claims against their card issuers, either through arbitration or through the courts. Another question our study addresses is the extent to which consumer finance class actions enable consumers to get financial redress. We focused our research on class action settlements because that is generally the way consumers obtain relief in class actions. These cases rarely go to trial. The same, as it was indicated, is generally true of individual court actions and to a lesser extent of arbitration cases as well. For the period from 2008 through 2012, we identified about 420 federal class action settlements in consumer financial cases. We found that those settlements totaled $2.7 billion in cash, in-kind relief, and fees and expenses. Of this, 18% went to attorney's fees and litigation and administrative expenses. This means approximately $2.2 billion was available as monetary and in-kind relief for the benefit of affected consumers. Further, these figures do not account for the benefits to consumers from lawsuits or settlements that led to changes in company behavior. This value is considerable but difficult to quantify. And, of course, the numbers do not include the potential benefit to other consumers from any deterrent effect associated with these settlements. In over 100 of these settlements, payments were made to affected consumers automatically without those consumers having to submit claims forms. For those cases where numbers were available, over $700 million was paid to consumers. We were able to obtain data on payments in another 125 or so settlements in which consumers were required to file claims in order to get their money. In these cases, we found that approximately $325 million was paid to consumers. In another 25 or so cases, a combination of automatic distributions and a claims process was used, and in those cases, roughly $60 million was paid to consumers. In other words, the total cash payout, excluding in-kind relief, was at a minimum in excess of $1.1 billion, or at least $200 million per year. These payments were provided to a minimum of 34 million consumers, which works out to an average of 6.8 million consumers annually. The contrast between the class action system as a means of addressing consumer claims as compared to arbitration and individual litigation can be especially stark if we focus on particular markets. Consider, for example, the checking account market. Over 90% of all American households, roughly 114 million of them, have a checking account, making this perhaps the single largest consumer market. Between 2010 and 2012, there were a total of 72 arbitration disputes filed with the AAA and 137 individual cases filed in federal courts involving checking accounts. Yet during those same 3 years, 6 class settlements were approved involving the overdraft practices of 5 banks. The settlements totaled close to $600 million and covered more than 19 million consumers. The cases also resulted in changes to overdraft practices going forward, changes that brought material benefit to consumers. A further question we studied is the extent to which arbitration clauses stand as a barrier to class actions. By design, arbitration clauses can be invoked to block class actions in court. We studied how often arbitration clauses are, in fact, used in this way. We found that it is rare for a company to try to force an individual lawsuit into arbitration, but it is quite common for arbitration clauses to be invoked to block class actions. For example, we found that when credit card issuers with an arbitration clause were sued in a class action, companies invoked the arbitration clause to block the action in nearly 2/3 of the cases. And in the overdraft litigation, which I just referred, 5 banks were able to get the class actions against them dismissed because of arbitration agreements. We also examined how often consumers seek to file class actions in arbitration. The AAA has a process that allows a consumer to pursue a dispute on behalf of a class of other consumers, just as one can do in court. However, under the AAA rules, a class action arbitration can only proceed if it is permitted under the arbitration clause. We found that nearly all arbitration agreements include a provision which says that arbitrations may not proceed on a class basis. Perhaps not surprisingly, we found that only 2 class action arbitrations were filed with the AAA between 2010 and 2012 in the markets we studied. One of these was not pursued after it was filed, and the other was pending on a motion to dismiss as of September 2014. In addition, we looked at whether companies that include arbitration clauses in their contracts are able to offer lower prices because they're not subject to class action lawsuits. Our methodology here centered on a real-world comparison of companies that dropped their arbitration clauses and companies that made no change in their use of arbitration clauses. This was possible because in 2009, 4 large credit card issuers had settled an antitrust lawsuit by agreeing to drop their arbitration clauses. Meanwhile, other card issuers had either retained their arbitration clauses or continued to refrain from using arbitration clauses. Using de-identified account-level information from credit card issuers that represent about 85% of the credit card market, we compared the total cost of credit paid by consumers of some of the companies that dropped their arbitration clauses and of some of the companies whose use of arbitration clauses was unchanged. We looked at whether the elimination of arbitration agreements led to an increase in prices charged to consumers. We found no statistically significant evidence of such a price increase. We likewise found no evidence that issuers which dropped their arbitration clauses reduced access to credit relative to those whose use of arbitration clauses was unchanged. Finally, our study examined the extent to which consumers are aware of and understand the implications of arbitration clauses. In our survey of 1,000 consumers with credit cards, we found that of those consumers who said they knew what arbitration was, 3 out of 4 did not know if they were subject to an arbitration clause. Of those who thought they did know, more than half were wrong about whether their agreements actually contained arbitration clauses. In fact, consumers whose agreements did not contain an arbitration clause were more likely to believe that the agreements had a clause than consumers whose agreements actually did have such a clause. The confusion did not stop there. More than half of the consumers who were subject to an arbitration agreement and who said they knew what a class action was believed that they could participate in a class action nonetheless. 40% were unsure whether they could, leaving less than 2% who recognized that they could not participate in class actions. We also asked consumers if they recalled being asked whether they wished to opt out of their arbitration clause so that they could retain their right to sue in court or participate in class actions. Over a quarter of the credit card arbitration agreements we reviewed permit individual consumers to opt out. However, only 1 consumer whose current agreement permitted him to opt out recalled being asked whether he wished to do so. In our governing statute, Congress specified that the results of this arbitration study are to provide a basis for important policy decisions that the Consumer Bureau will have to make in this area. So people are right to be interested in digesting these results and considering how we intend to fulfill the objectives established by Congress. We will be meeting with stakeholders after they had a chance to read our report, and we are here today to invite you to share your thoughts on these issues in general and on that process in particular. At the Consumer Bureau, we're dedicated to a marketplace characterized by fair, transparent, and responsible business practices. We believe that strong consumer protection is an asset to honest businesses because it ensures that everyone is playing by the same rules, which supports fair competition and positive treatment of consumers. We look forward to a robust and vigorous discussion today, which will bring us one step closer to achieving that vision. Thank you.
Thank you, Director Cordray. At this time, I'd like to invite the panelists to take the stage. While they are doing so, I'll briefly introduce CFPB staff and our guest panelists. I'll start with Steve Antonakis, who serves as the Deputy Director as well as the Associate Director for Supervision, Enforcement, and Fair Lending at the CFPB. He is responsible for the supervision of all banks and non-banks under the CFPB's jurisdiction, as well as the enforcement of federal consumer protection and fair lending laws. We also have with us David Silberman, who is the CFPB's Associate Director for the Division of Research, Markets, and Regulations. We have Gail Hillebrand, the CFPB's Associate Director for the Division of Consumer Education and Engagement. Our guest panelists are Alan Kaplinsky, partner with Ballard Spahr, LLP, Dong Hong, Vice President and Regulatory Counsel with the Consumer Bankers Association, Louis Vatiri, President and CEO with Garden Savings Federal Credit Union, Jane Santoni, partner with Williams and Santoni, LLP, Professor Miriam Gillis, Professor of Law, Cardozo School of Law, Yeshiva University, and Paul Bland, Executive Director with Public Justice. Steve, you have the floor.
Great, thank you, Zixta, and good morning to everyone. Let me thank you all for joining us today in New Jersey. Also, let me thank Bureau staff in attendance today that worked so diligently on the arbitration report. As Director Cordray mentioned, the arbitration study was mandated by Congress and is the first step in the Bureau's consideration of arbitration clauses in consumer credit contracts. We were fortunate to have received a wide range of comments from interested parties to date, and we expect that the report we're releasing today will generate even more discussion. These diverse viewpoints make us better, and they have improved our work immeasurably. We'd like to kick off our dialogue this morning with a panel of experts that Zixta Martinez just briefly introduced. Each panelist will speak for approximately 3 minutes, and then I'll be joined by my colleagues David Silberman and Gail Hillebrand in a question and answer panel for our panelists. At this point, allow me to introduce our first panelist, Alan Kaplinsky, who will get us started. Thank you, Alan.
Thank you, Steve, and thank you, Director Cordray, for inviting me here today. It's really my pleasure. Good morning, everybody. I'm Alan Kaplinsky, and I'm a partner of Ballard Spahr, and I'm chairman of our firm's Consumer Financial Services Group, which is about 100 lawyers spread out over 14 offices. I think it's fair to say that arbitration is a topic pretty near and dear to my heart. I did, along with my colleagues, do a lot of pioneering work in the area. I did it because this happened back in the mid-90s. My clients considered the legal system to be broken. They were being sued in locations that are commonly referred to back then, and unfortunately even today, as judicial hellholes, where a large company could not get a fair shake in court. Every case would end up in a jury trial. There was no such thing as being able to get rid of a Aha, I apologize. I have a built-in microphone, so very often I forget to actually turn on the real microphone. My partners and I fought vigorously to have consumer arbitration agreements enforced, and we did play a central role in what became a great debate over the role of arbitration as a forum for resolving consumer disputes. And while we were advocating on behalf of our company clients, I've also personally and professionally believed that arbitration is good not only for companies, but also for consumers and the public at large. The vast majority of consumer disputes are resolved without either arbitration or court litigation. Most consumers are able to resolve their disputes with companies using helplines or informal dispute resolution procedures, or third parties such as the Better Business Bureau or even the complaint portals that are maintained by the Bureau and most state attorneys general. But if a dispute does escalate beyond that point, we need to ask ourselves the following question. What does the average consumer really want for himself or herself in a dispute resolution process? What has been the experience of consumers who've actually participated in arbitration? There's no information, as far as I can tell, in the report issued by the Bureau dealing with interviews that the Bureau has conducted of real live consumers who have gone through arbitration. And this question, unfortunately, and I think a central question, has been completely ignored. If that's so, it's very unfortunate, because it seems to me that consumer satisfaction, which the Bureau is always saying is important in other areas, that is very central here, and it's been ignored. From the very beginning, I counsel my clients to implement arbitration programs that were fair, so that both parties, whether they won or lost, would view dispute resolution in a positive way. It's always seemed to me that arbitration is a great solution for both consumers and companies, because everyone benefits from a process that's faster, cheaper, and more efficient and congenial than court litigation. Consumers find going to court very intimidating. At the same time, we were aware of arguments that consumers should not be bound by arbitration clauses contained in form contracts. So we even urge clients to give consumers an unconditional right to reject the arbitration clause without affecting any other terms of the contract. And I'm very pleased that a majority of our clients accepted that advice. Since my firm has participated in many arbitrations, I've witnessed firsthand the many benefits that consumers actually realize from arbitration. In what other forum, I ask you, can a consumer sit down at a conference table with the decision maker and tell his or her story uninterrupted from beginning to end? And arbitration costs the consumer far less than what it costs to file a lawsuit in court. In my experience, and it's substantial here, in terms of actual results, consumers do at least as well in an individual arbitration, and very often they do much better than the consumer fares in court. And if you were to ask the consumers who've been through that process, again, what their experience was with arbitration, as opposed to asking people who never experienced what it was through asking hypothetical questions in the telephone survey that the Bureau conducted, I think you would hear a lot of positive things. but I'm not sure that the Bureau wanted to hear positive things about arbitration. Compared to the court system, consumer arbitration is in its infancy. In my view, it's not really probative to say today that consumers must not like arbitration because there are relatively few arbitrations compared to the number of court cases, because the benefits of arbitration are only beginning to be realized. Another reason for this is that many plaintiffs' lawyers don't like arbitration because it's against their self-economic interest, and they have railed against it for more than a decade. And this is basically a public relations problem. And I believe that through the media repeating what the plaintiffs' attorneys have said, it has dissuaded a lot of consumers from getting a complete picture of what arbitration is and what the benefits are that can be offered. And this is another area where I think the Bureau has dropped the ball. The Bureau could have played, and still could play, a constructive role by having its consumer education and engagement arm explain to consumers in a neutral way how the court system works and how arbitration works. And also remind consumers that there are contracts that go along with credit cards and loans and other consumer contracts. The Bureau's press release emphasizes, quote, more than 3 in 4 consumers surveyed do not know that they're subject to an arbitration clause. Well, we in the industry have bent over backwards to clearly and conspicuously disclose to consumers if a contract has an arbitration clause. So if the Bureau's statistics are correct to us, that means that people aren't reading what we're disclosing. And it's not just that they're not reading the arbitration clause, they're not reading any part of the agreement. The cure for that, in our view, is to better educate consumers to pay attention to what they are signing.
Thank you, Mr. Kaplinski. If you have more to say, we'll come back to you in the question period. You've
Sure.
exceeded your time.
Yeah,
Thank you.
Thank you.
Great, thank you. Dawn?
Thank you for inviting me to speak today. My name is Dong Hong of the Consumer Bankers Association, a national trade association representing the retail banking industry. We appreciate the opportunity to speak on the importance of maintaining arbitration's role as a convenient alternative dispute resolution process for consumers. In comparison to litigation, CBA believes arbitration provides consumers with a better, cheaper, faster way of resolving any disputes that they may have with their financial institutions. Arbitration is better for consumers because it provides a relaxed, informal forum in which to state their case and be heard by an impartial arbiter, without the formalities or intricacies of a court trial that necessitates the services of an attorney to navigate. Arbitration is cheaper for consumers, as they are generally only required to pay a nominal filing fee that compares favorably to the filing fee for federal court cases. Arbitration offers a faster process to resolve disputes, which can provide a final decision in a matter of months, rather than the years it may take to receive a final court decision. And at the same time, studies have shown that consumers generally obtain better outcomes with arbitration than through litigation or class action suits. Furthermore, consumers at large ultimately benefit from arbitration because the cost savings to financial institutions from avoiding drawn-out litigation can be redeployed towards other useful purposes, like mobile banking, cybersecurity, along with greater access to credit. Many of CBA's members have long expressed the view that there are fundamental flaws in our judicial system, such as the length and cost associated with trials, an aggressive plaintiff's bar that is financially motivated to pursue frivolous lawsuits, and class action lawsuits geared toward rewarding trial attorneys rather than seeking a remedy in the best interests of consumers. This is not just CBA's opinion. Congress reached the same conclusion when it passed the Federal Arbitration Act, and the Supreme Court has made similar findings, like in its 2011 AT&T versus Concepcion decision. Finally, if we take a step back from this debate to inject a bit of perspective, recall that arbitration and litigation are only the last legs of a long set of measures designed to protect consumer interests. We cannot view arbitration in a vacuum. Financial institutions have implemented a host of informal dispute resolution processes to address consumer concerns, such as through customer care and complaint resolution personnel. The vast majority of issues are addressed here. In addition, CBA members operate under a comprehensive, overlapping bank regulatory system made up of state and federal supervisors and enforcement agencies, including the CFPB. Lastly, many of these agencies, like the CFPB and the federal banking regulators, have implemented consumer complaint databases in order to mediate certain disputes between consumers and their financial institutions. In conclusion, we believe arbitration is the best path forward because it's mutually beneficial to all parties. CBA will take the time to thoroughly review the CFPB's findings in its arbitration report, and given some of the summary findings that were outlined by Director Cordray in the opening remarks, we look forward to an opportunity to continue the dialogue with the Bureau on educating consumers about arbitration. Thank you.
Thank you, Dong. Next, we'll hear from Louis Viteri, President and CEO, Garden Savings Federal Credit Union.
Thank you, Deputy Director. As he said, I'm Lou Viteri. I am President and CEO of Garden Savings Federal Credit Union, which is located right here in northern New Jersey. I'm also the immediate past chair of the New Jersey Credit Union League, which represents all credit unions in New Jersey. Credit unions are different than other financial institutions in that, generally speaking, we're smaller and we are member-owned. And the member-owned is a huge differentiator for us. We don't have outside stockholders. We don't have investors. Everyone who is a member of the credit union is an equal member. Whether you have $5 on deposit or $500,000 on deposit, you have the same vote and the same ownership as each other. Garden Savings is, I'll say, a mid-sized credit union. We have about $300 million in assets, roughly 28,000 members, mostly in northern New Jersey, about a $200 million loan portfolio, and a fairly small credit card portfolio hovering around $7 million. We are consumer-facing, and as a result of that, we have, I'll say, a different approach towards dispute resolution. The New Jersey Credit Union League represents almost 200 financial institutions in New Jersey that have roughly $12 billion in assets. So they are representative of a much larger, but certainly not a huge segment of the population. We are in favor of arbitration. However, I will say that we would not mandate it. We believe in resolving disputes first from a member service perspective, from a face-to-face perspective. We do not want to deny our members the ability to take us to court, whether it be one-on-one or through class action. We believe they have that right. That said, we also believe that arbitration is a much more cost-effective and financially viable with as good a result as a court ruling, and can be done in a much quicker setting. I just want to say that as a CEO, I get to see this operationally day to day. Credit unions, generally speaking, do not have arbitration clauses in their agreements, whether they're credit card agreements or deposit account agreements. If you look at the results of the preliminary study, you'll see credit unions had about 3% of the credit unions in the nation, or that were surveyed, had dispute resolution as their primary means of settling disagreements. And on the checking account side, it was about 8%. It is not a form that we insist on. Rather, we would like to leave that up to our members to decide which way they would like to pursue. Thank you.
Great. Thank you, Lou. Next, we're going to hear from Jane Santoni, partner at Williams & Santoni. Jane?
Thank you. Good morning, ladies and gentlemen. As stated, my name is Jane Santoni, and I am a private consumer protection lawyer. I am one of very few such lawyers in the state of Maryland, and I'm here to talk about my experience with forced arbitration. A few years ago, I represented a woman who was sold a lemon buyback. In other words, the manufacturer had rebought the car because of serious defects and then resold it to my client without telling her. This dealership was doing this on a regular basis. We filed a jury trial. The jury agreed that what the dealer was doing was wrong and found in our favor. They found that the dealership rightfully had committed fraud and violated the Consumer Protection Act. After we filed a second lemon buyback case, the dealership settled that and told us that they were not going to sell lemon buybacks anymore. In contrast, last year I tried to file suit against a car dealership that regularly sells people cars and then cancels the contracts, keeping their down payments and their trades. According to that dealership's CEO, 2 such dealerships, and there are about 150 throughout the country, do this about 96 times a year to the tune of keeping about $100,000 a year. 2 dealerships. That is a lot of money for 2 dealerships and an extraordinary amount of money for 150 dealerships to keep these down payments and trades from customers who think they've bought a car and then find out that they really haven't. My clients didn't want to arbitrate that case. They wanted a jury to decide what that dealership had done to them, but they were forced into arbitration. The arbitrator agreed that the dealership acted illegally by keeping the down payment and the trade money. He said the dealership had to give that money back. That was about $3,500. However, he refused to find that the dealership had committed fraud or acted unfairly. This is not unusual. In fact, in every arbitration that I've been a part, the arbitrator has given something small, but has refused to find that the corporation violated the Consumer Protection Act, made misrepresentations, or acted fraudulently. Even so, this was a pattern illegal behavior. Keeping people's down payments and trades was found to be illegal even by that arbitrator. 95 other people every year in these 2 dealerships have the same thing happen to them. But I can't help them get their money back because every one of their contracts contains a class action band and an arbitration clause. And the award is too small for me to be able to help these people on an individual basis. So the car dealership continues to profit from breaking the law, and we can't do anything about it. These are only 2 examples, but my experiences in the last 12 years as a consumer protection lawyer who has tried both jury trials and arbitrations is that the arbitrations never turn out better for the consumer. My experience is that they are not shorter, less expensive, or more fair. In fact, just last week, we had a client come in who was forced into arbitration, and then the company, the corporation, wouldn't pay the arbitrator's fee, dragging the matter out for months and months and months. A few years ago, I was in a courtroom fighting an arbitration clause, and the corporate lawyer was making the argument that forced arbitrations are really better for consumers. However, every individual in that court that day, it was about a dozen people, were desperately trying to get their case heard before a jury. It was the businesses, the corporations, who were fighting it tooth and nail. Only the corporations thought it was better for the people who didn't want them. I mentioned this to the judge, and I said, there are so many people here today who are fighting this. He said, Ms. Santoni, that's my experience every single week when I hold these hearings. The individual consumers are desperate to get their constitutional right to a jury trial, and the businesses are fighting them tooth and nail, claiming that they would rather have their constitutional right. If this is so...
Santoni, we'll come back to you again in the question round and appreciate your comments.
Great. Thank you. Next, we're going to hear from Miriam Giles, Professor of Law at Cardozo School of Law, Yeshiva University.
Miriam Gillis, Cardozo School of Law. Thank you so much for having me. So I just say this study is incredibly impressive. I have not read all 700 pages of it, but it is an incredibly impressive study. I'm so impressed with the work that went into it, with the data that was assembled and analyzed. It's a really great portrait of consumer financial arrangements, and I think it's going to be useful to policymakers and scholars for years to come. But at the end of the day, and this is not to put this study down, but at the end of the day, what this study really does is it confirms common sense. Common sense tells us that consumers are not going to individually arbitrate claims that are worth less than, say, a few $1,000s, because it's just not really worth it, right? Why would any of us arbitrate a claim when it would cost more to file and actually pursue the claim? We're not going to do that, so that's common sense. It's also common sense that consumer-facing companies, the kinds of companies that Mr. Kaplinski represents, are going to try to insulate themselves against class action liability any chance they get. And right now, they have a great chance, right? Because the Supreme Court has made it perfectly clear in Concepcion and Italian colors that there's just really no limit to what companies can do in terms of putting class action bans into their arbitration agreements. So it's common sense that companies are going to do this, right? They're going to put as many class action bans into as many arbitration clauses as they can find, which explains why tens of millions of American consumers find themselves subject to these clauses today. It's also plain common sense that any consumer faced with a choice between cell phone providers or credit card products is not going to make that choice based on the dispute resolution clause, right? None of you look at your cell phone opportunities and think, is there a mandatory arbitration clause in there? We don't do it, right? And it's also common sense that most consumers aren't even aware that they are subject to arbitration clauses. And we're never aware. I think there was one consumer who says he was aware of a limited one-time opt-out right. I mean, that just doesn't happen. So all of this is common sense. We all know this as we sit here. Problem with common sense is that it's really not a good enough predicate for making good sense regulatory or legislative policy, right? Because I've been saying for years in my little itty-bitty law review articles and on panels that look a lot like this, that this is all common sense. That forced mandatory arbitration has nothing to do with dispute resolution, or efficient dispute resolution, with forum selection, that all of that is just not at all what's at stake here. What's going on is liability avoidance, right? That's what companies want. They want to avoid liability. It makes total sense that if you prohibit consumers from banding together to bring their claims, companies are going to be able to violate the rights of thousands of consumers and never, ever face any liability. That's common sense. But the problem with common sense in today's political environment is it's not good enough, right? It's not good enough. And when it's not good enough for making policy, you have to do something like what the Bureau did. You have to muster incontrovertible, really strong, irrefutable empirical evidence. And that's what the Bureau has done with this study. I mean, this is an incredibly impressive study. And so I applaud the Bureau. I think that this will form the basis for responsible rulemaking. And I encourage the Bureau to ban arbitration clauses in all the consumer financial contracts over which it has jurisdiction under 1028A of Dodd-Frank. Thank you.
Thank you very much. And lastly, we'll hear from Paul Bland, Executive Director of Public Justice.
This study should change the debate about forced arbitration forever. For about a decade, you've had this divide where consumer advocates and civil rights advocates would come and say that forced arbitration was just devastating to our clients, left them without any remedy if the law was broken and they were harmed. And then you would have sort of the lobbyists for the credit card companies and the payday lenders who would come in and say, oh no, it's actually great. When we force consumers into arbitration, it's really for their own good. We're trying to help them out. And then reporters would say, well, there's a story about forced arbitration. He said, she said, and it would sort of just sit there. That has changed. Now we have overwhelming empirical evidence that shows that forced arbitration strips consumers of any way to protect themselves. When credit card companies engage in bait and switch tactics, When payday lenders engage in predatory behavior over the internet, rip people off, there is no accountability. It is easy to break the law and for a lender to walk away right now if they have a forced arbitration clause. This idea that arbitration is a shift from court to arbitration, from one form to another, it's a fairy tale. It is a lie. What happens is that the vast majority of those cases just disappear. Cases that used to be in court go nowhere. They don't go to arbitration. There's a series of examples in the empirical evidence in this study that show that you will have two companies, two lenders, breaking the law in the same way. One of the lenders won't have an arbitration clause because of the timing of the case or because of something to do with their lawyers. And when they are caught breaking the law, they have to pay refunds to everybody, fix their credit reports, walk away from illegal debts. Then the study shows that there are a bunch of other lenders who do have arbitration clauses who walk away scot-free. They are good to go. They pay nothing. After today, this is no longer a serious debate about what the evidence shows. The banking lobbyists, the payday lending industry lobbyists who are saying that forced arbitration is good for consumers, they stand in the same shoes as the remaining PR guys and lawyers who say that cigarette smoking is good for children. This is no longer a serious public policy debate. The evidence is on one side, and then there's money on another side. There is something that was lost in the empiricism of the study, though, and there's one thing I'm disappointed about, and that is that history and context have been lost in a very significant way. Between 1998 and 2008, by far the biggest provider of consumer arbitration services in the United States was an entity called the National Arbitration Forum. It operated in a fundamentally corrupt way. They basically sold themselves to lenders with a wink and a nod, doing advertisements saying, if you're a bank or a payday lender, bring us in as your arbitrator and we'll give you a good deal, in very, very blatantly unfair advertisements. They were hired, then they went ahead and if the arbitrator ever did rule for a consumer, there were a series of cases in which arbitrators were blackballed. There were cases in which arbitrators ruled for consumers and the front office came and overturned it. They operated in such a corrupt fashion that at some point, a state law enforcement office, the Minnesota Attorney General, looked into them, and it turned out that there was an undisclosed conflict of interest where the same debt collectors that were going and filing tens of thousands of cases in front of them owned $40 million of this company, okay? And then they were shut down within a week by law enforcement. So the biggest arbitration company in the United States was shut down by law enforcement, and no court was going to do anything about it for a decade. They just got away with it. And consumers would come in and challenge it, and courts would say, well, the Supreme Court's just said we love arbitration, we're going to step back. That could easily happen again. Increasingly what you're seeing is you're seeing sort of marginal market actors moving away from companies like the American Arbitration Association and getting Fred's arbitration service. Are they another national arbitration forum? Are they another corrupt entity? How is anyone going to find out? And that history has all gotten lost. So I think numbers are great, and I'd say that the authors of the study did a great service to all of us, but losing the history was a shame. The last thing I just want to say is, the study proves that these are not a voluntary choice, these forced arbitration clauses. 75% of consumers subject to arbitration didn't know that there was an arbitration clause, and only 7% of people who had an arbitration clause knew that meant that they couldn't go to court. Now, the bank lobbyists say, well, it doesn't matter whether people understand or not. We should educate them to read every word of the multi-thousand-page fine print contracts. Well, that education, I imagine how that course is going to be undersubscribed. Look, I reject the idea that it is okay in the United States of America to strip people of constitutional fundamental rights and say, oh, well, it was their fault for not reading all the mouse print buried someplace on some deep page on the internet. That's ridiculous. This is unfair.
Thank you, Paul. So let me thank all of you for your opening comments. It seems we do have a variety of views present today. We will now transition to the question and answer segment of the panel discussion. You all of our panel members have a great deal to add to this discussion, and I would ask that you limit your responses to 2 minutes so we can hear from all of you. I have the first question, and it is for Alan. Alan, you got into this to some degree during your opening comments, but I would just give you the opportunity to tell us why you believe companies used pre-dispute arbitration provisions.
Yeah, well, as I had indicated, Deputy Director, that we believe, and our clients have believed for years, that the legal system is broken in a lot of places. And that includes class action litigation. And that was the main thing I didn't get to in my opening remarks. And this is, again, where I think the Bureau missed an opportunity to focus, they focused on the benefits of class action litigation, but they didn't spend very much time talking about the drawbacks. So I did a little bit of speed reading this morning. We didn't get the study until 8 o'clock in the morning, the actual study. And this information, which I'm going to tell you, is not in the press release, and it's not in the fact sheet, and it was not mentioned by Director Cordray. And I think it's very important. Of the class actions that they studied, 25% were resolved through individual settlements. 35% included a withdrawal by the plaintiffs or a failure to prosecute the class action. Only about 15% obtained final settlement approval. Not one class action case went to trial during the period studied, and I would say the fact that 60% of the class actions that they studied settled individually or just disappeared demonstrates that the majority of the class actions are frivolous or they're filed for purposes of extracting an individual settlement from companies. And there are costs associated with defending those kinds of cases and having to pay out individual settlements. Final point I want to make is that the numbers sound very big. They're very impressive, but they are aggregate numbers. There's no individual information. So if you pay $1 to 30 million people, that's $30 million, and that sounds impressive. But if you're a consumer, like me, where I've received in the mail as a part of a class action settlement, a check for $2.50, I'm not very happy with that. And I submit that those individuals, if properly educated about the rights that they have in arbitration, would have done much better going through arbitration.
Thank you, Alan. David?
Sure. So let me ask, Jane, ask you a question. You talked in your remarks some about the effect that you've seen arbitration have on individual consumers. And could you add more about your experience and what you've seen in terms of the effect of arbitrations on consumers?
Sure. Well, it's sort of like when a person owns a house, and if, in fact, they are never robbed, they never think about the criminal justice system. But if they get, so for a consumer who never has an issue, they don't care. But when your house gets broken into and you say, well, now I want to call the police and I want to prosecute, you expect that you have a way to call the police and prosecute. The problem with the arbitration clauses is essentially that's taken away. My colleagues throughout the country and I can't take these cases because the arbitration results are so poor for us, so we turn them down. Cases that I used to be able to take, I don't take anymore. So it's akin to the person who's being robbed who now says, well, wait a minute, I want my justice, and I have to say, I'm sorry, but I can't, that trial that you think you get, you don't get. And when I say to them, and by the way, did you know when you signed this contract that this is what you were saying? There's not been a single client in 12 years who I've asked that question to, and I ask it a lot, who has said to me, oh yes, I knew I was waiving that right, and I thought this was a better way to go. So for the people who actually have wrongs done to them, we can't get them help. It has an astronomical chilling effect.
My question is for Louis Viteri. You talked about credit unions and how they use arbitration clauses. The CFPB research found that credit unions are less likely than other types of financial institutions to use an arbitration clause. What factors do you consider in deciding whether or not to use these provisions?
That's a great question, Gail. I think there's a few things at play here. Number one is the size. Most credit unions are smaller financial institutions, community-based. At this point in time, I think there's 3 credit unions that reach the threshold or are over the threshold of CFPB guidance. And there's almost 6,800 credit unions in the United States. So size certainly plays into the decision. But I think more importantly is our structure. As I mentioned, we are member-owned. So we are not answering to shareholders. We don't have stock options. We are serving our members who are our customers, who are our owners, all one and the same. And I think we have a different perspective when we look at them and how we're trying to serve them. As a result of that, I think credit unions in general are, I'm going to say, kinder, gentler financial institutions. That's our composition. We think, as several people have pointed out already, we don't want to take away their right to sue us. I mean, if they believe that they have been wronged and they want to sue us, they should have that right to do that, whether that be individual lawsuits or class action lawsuits. Alternatively, I am a huge believer in arbitration as a means of settling potential lawsuits, but that should be at the option of the customer and negotiated once we understand the claim. So Garden Savings does not have any pre-dispute arbitration clauses in any of its contracts. As is pointed out in the study, most credit unions do not. There are a few that do, and I think that they may be the result of one of 2 items. Maybe they have been sued in the past and have had bad experiences, or number 2, many credit unions use third-party providers for credit card agreements. Some of those providers may have that pre-resolution in the contract. To be honest with you, I actually don't know. I'm not sure what credit unions use that as a forum, but as a general rule, I'll say credit unions do not use that, do not pursue that. I've been CEO of this credit union for 10 years now. I believe over those 10 years, we've been involved in 6 litigation. All 6 of those were settled through arbitration or mediation, but they were brought through the courts first.
Paul, let me bring you into the conversation. As you know, today's report was issued pursuant to a provision in the Dodd-Frank Act, which was enacted in 2010. So can you talk a little bit about how the Supreme Court decisions have changed the landscape since 2010 when it comes to arbitration, particularly in consumer finance?
Yes. So it used to be that if you had an arbitration clause that was really unfair, that it was possible to go to court and challenge it, and courts frequently struck down arbitration clauses that had added a bunch of other provisions to the clause as being unconscionable. In 2010, in a case called Renner Center versus Jackson, by the usual 5-4, the Supreme Court said that there are certain circumstances in which the arbitrator can decide whether the arbitration clause is fair or not. And basically, the bank can write the clause so that the arbitrator will decide nearly all challenges. So in the wake of that, a lot of arbitration clauses have become dramatically less fair. Not as much at the top tier, like Citibank or AT&T kind of thing, but if you're debt settlement firms, your payday lenders, and these sorts of entities. So in recent months, you've seen one state court of appeals upheld an arbitration clause that shortened the statute of limitations to 30 days. So the legislature said you have 3 years, and this lender decided to give itself 30 days. Recently, the Second Circuit allowed essentially a financial scam artist to be covered by any rule that the Bureau had to say that a consumer who'd been ripped off in Long Island would have to travel to Phoenix, Arizona to bring her case. And the Second Circuit said, well, seems really unfair to us, but Justice Scalia told us we had to do it. Similarly, in April of 2011, in the Concepcion versus AT&T case, it used to be the case in America that if you could go in and prove to a court that enforcing an arbitration clause would gut the consumer protection laws, that the courts would strike down those arbitration clauses. So there were more than 20 state courts that had either state Supreme Courts or appellate decisions, and there were 8 federal circuits that had struck down arbitration clauses where you had that kind of proof. And in the Concepcion case, and then later in the Italian Colors case, the Supreme Court said, we don't care. Even if it would completely gut consumer protection laws, civil rights laws, antitrust laws, anything, if there's an arbitration clause, that's just more important. Essentially, the Supreme Court said in their view the Arbitration Act is their favorite, by the 5 of them think that the Arbitration Act is their favorite act in the entire book of the U.S. Code, and it just always wins whenever it strikes down some other type of law.
Thank you. Dong, in the Dodd-Frank Act, Congress barred arbitration clauses in mortgage contracts? Should arbitration provisions related to other consumer financial products be treated differently, and if so, why?
Thank you for the question. In preparation for this field hearing, I actually did go back to the Dodd-Frank Act and take a look at the handful of provisions that deal with arbitration in the law. And quite frankly, I'm not sure what motivated Congress to take such a bifurcated approach. I can't find any rationale personally from the legislative history of the act. I know that there have been discussions around arbitration for quite some time now, but I'm not going to speculate at this time what motivated Congress to take the bifurcated approach. But I will ask, however, maybe if you turn the question around a bit, it may be worthwhile to ask why Congress directed the CFPB to re-examine the use of arbitration agreements in all consumer financial markets, but then decided to take away that option in relation to housing finance-related transactions. I'm not, like I said, I don't really know the answer to that, but CBA thinks that Section 1028 of the Dodd-Frank Act actually takes the right approach, and it should have covered all consumer financial markets. A thoughtful examination of all the available dispute resolution processes, followed by input from all stakeholders in these financial markets, I think would have come out with a better result in the end.
Thank you.
My question is Professor Miriam Gillis. The CFPB report has a very empirical focus. Are there other potential benefits and costs in arbitration provisions that might be hard to reflect in the numbers?
Yes, thank you. Thank you for that question, because I do think there's at least one aspect to shunting off claims into private arbitration that's really difficult to capture in the empirical analysis, and yet it's critically important, and that's the effect on the development of law itself. What happens to our common law when all these cases that would have ordinarily been brought in public courts are instead sent off into the private, hermetically sealed vault of arbitration, never to be heard from again? What happens to the law? I think that's really critical because arbitrations are, by contract, one-on-one confidential affairs. Arbitrators do not, for the most part, write precedential decisions. Few records of the proceedings are kept. I mean, this is about as different from public court as you can get. So, the common law in this country, which we're very, very proud of, is made up of some pretty basic elements. We need publicity. We need preclusion principles. We need stare decisis. All of these are totally absent in private arbitration. So imagine that all consumer contracts contain arbitration clauses, which will happen unless these things are banned. And that means that all consumer claims will be decided, if at all, right? Because we're not actually conceding that there are going to be any decisions, but they will all be decided in private arbitration. And that means the common law doctrinal development in the area of consumer law will cease. It'll stop. It's over. So if you're wondering, for example, whether credit card companies that charge an early termination fee are violating state consumer protection laws, or if you're wondering whether these online websites that we all use that all promise the best price, and yet they all offer us the same exact price, whether that's a violation, or whether these data breaches that we're all hearing so much about, whether these are actionable under state or federal law. If you wonder about these legal questions, well, too bad. You're not going to know the answer to these legal questions because these were all cases that were decided post-concepcion where courts upheld mandatory arbitration clauses and sent these cases into arbitration. What that means is that we don't know anything about these cases. There's no airing of the facts. There's no public analysis or explanation of outcome, context, or implications. I think this is really serious. And if I can go on for just one moment longer, just a plug. So I just wrote a paper where I looked at all cases arising under the Illinois Consumer Protection Act between 2005 and 2014, pretty random sample. And I asked these two questions, really simple questions. How many of these cases would still be in court if arbitration clauses had been in full force in the underlying contracts? And second, had all or many of these cases been subject to private mandatory arbitration, what would be the implications? What loss of law, what loss of doctrine, what loss of important precedent, what doctrinal developments don't happen if all these cases are sent into arbitration? So you can tell, I think, what my conclusions were. Most of these cases would find themselves in private arbitration, 46 out of the 70 that I looked at, and those were conservative estimates. These cases disappear from the judicial docket. I think the answer to the second question is also not so surprising. The loss of those cases would have had immense impact on the development of consumer law, and this is just a tiny sample. So I think that that's an incredibly important loss that we ought to focus on as well. Thank you.
Great. So thank you, everyone. So we're going to move into our lightning round at this point. We have one question left that we'll have all the panelists respond to. The question that was prepared for me is, do arbitration clauses help consumers? I think we have a good sense for the views of the panel members at this point in time. So instead, I'll give you each a minute, just if there's anything else that you wanted to add to this discussion that you haven't had the opportunity to do so as of yet. Alan, we can start with you, and we'll just work all the way around the table.
Yep. And I promise I will keep to a minute. The one other thing that has not been mentioned today, and I don't know whether it's dealt with in the report, it's not mentioned in the press release and the other material that we received, and that is the role of government enforcement. And in particular, the CFPB, the Department of Justice, Federal Trade Commission, State Attorneys General. And I submit that if there is a small dollar claim that can't be dealt with and effectively in arbitration, and by the way, small dollar claims don't go through arbitration generally because there is a small claims court carve-out, Professor, and that's why you don't see those kinds of cases in arbitration. But if there is a systemic problem, I don't have a problem with the CFPB or the other government enforcement agencies dealing with the problem. And boy, has the CFPB dealt with the problem. 70 consent orders, hundreds of millions of dollars of restitution, civil money penalties, and that's just one agency. So let's not think that just because class actions may not be available as a resource to consumers, that's a get-out-of-jail-free card for companies, because believe me, it's not.
Thank you, Alan. Don?
It's hard to follow that. I guess in my final remarks, I just touch upon some of the remarks that Alan has made, and maybe get a broader perspective. I do believe that it's important to keep in mind that arbitration or litigation is not the first way to resolve a dispute. There's many components, many tiers and levels of dispute resolution processes that are kind of built into the system, particularly for our membership. And I know the CFPB, as well as other of our supervisory agencies, have done a good job in establishing their own kind of informal resolution processes, almost serving as a middleman or a clearinghouse for complaints between the relationship between consumers and our financial institutions generally. So I just do want to emphasize that point. The other thing I want to mention is that when I take a look at this study, one of the things I'm really going to be focusing my attention on is if you had an opportunity to actually survey or talk to consumers who have actually had the experience of going through arbitration or litigation or a class action suit, just to see, for my own information and the education for everyone involved in this process, to understand how consumers feel and if they're satisfied with any of these processes at all. And the final point I would make is that, dovetailing with Dr. Cordray's remarks in the get-go for this field hearing, I think there is definitely an opportunity for additional education. And one other additional note is I think there might be an opportunity to work between CBA and CFPB to figure out ways to make arbitration even more convenient for consumers. Maybe perhaps that's a way to address issues that might have gone unresolved in the past.
Thank you, Don. Lou?
I'll be short and sweet. I don't believe that we should take away a consumer's right to litigate. That said, I believe arbitration and mediation are phenomenal avenues to pursue if litigation is not the optimal choice. Thank you.
Thank you, Lou. Jane?
My answer to your question is no.
Noted.
I'd like to address first the small claim. I will tell you that that people under most arbitration agreements do have the right to go to small claims court. That hasn't changed. The problem is that most lawyers can't help them with that because the cases are so small. And so most of what I handle are cases involving people who aren't just ripped off for, a few $1,000s or a few $100s, but people who have lost their cars, people who have lost their homes, people who are getting their wages garnished illegally. These are all individual cases of people whose lives are just being majorly screwed up because somebody did something wrong. And so that they don't fall in that small claim, but they sure as heck fall in the arbitration clause. And I can't help them under the current system. As far as government enforcement, you hear all the time, well, just let them, the government will enforce. The example of the case I gave you with the car dealership that was keeping the down payments, I asked every government agency I knew to look into that. And I have a lot of respect for those government agencies, but I'm still waiting for them to do something. So they have limitations, and it's something that we can certainly fill a role in the court system. And then finally, I don't say arbitration is bad. It can be a wonderful tool after a dispute arises. Wait till after the dispute arises. Don't force it on people before then. That's all we're asking.
Thank you, Jane. Miriam?
I obviously agree with everything Jane just said. I don't think arbitration clauses are good for consumers. I think the study bears this out. So I think we can stop having this debate. All mandatory forced arbitration does is suppress claims, keep information about corporate practices that affect all of us out of the public sphere, because we never hear about these claims. Corporations are not held accountable. It is a get-out-of-jail-free card, whatever Mr. Kaplinski says. They get a pass, and we have to worry about the marketplace, about who we trust in the marketplace. And I agree. I think that this argument, which is so interesting from business interests, which tend to want smaller government, that say, let the public enforcer do it. Look, public enforcers are stretched quite thin, and it was the recognition of these resource limitations that led state legislatures to enact private rights of actions for private individuals and groups to pursue violations against unfair competition laws, et cetera, at the state level. So I don't think that that's a proper response. I think it's pretty clear. This study makes it very, very clear that we need to level the playing field by allowing these claims back into courts, both class and individual claims, where they belong. And arbitration can continue to do the work that it had done really well before the Supreme Court decided to turn it into something that it isn't, where businesses, sophisticated businesses, are negotiating for expert arbitrators to resolve complex disputes that arise between them. Arbitration can be fine, but it's not okay in standard form agreements used against consumers. Thank you.
Right, and Paul, thank you.
The consumer protection laws matter. Bait and switch scams by lenders ruin lives. When consumers think loans are cheaper than they really are, it hurts them. People end up on debt treadmills. Some people end up without homes. People drop right out of the middle class. When private citizens lose the right to enforce consumer protection laws, and predatory lenders can just break those laws with no accountability, that's disastrous. This is a really exciting and incredibly cool day. For years, we have watched, by a 5-4 majority, the Supreme Court devolve the law in this area, strip away consumer protection laws, gut people's rights to protect themselves. It has been incredibly depressing to be a consumer protection lawyer for years. This study changes everything. It lays out an empirical record that shows that the Bureau should and can use its authority to turn this all around and to fix this problem. I am so excited to be in a place where you can actually feel optimistic that instead of waiting to see what terrible thing is the Supreme Court going to do next, that the world has the possibility of getting better for consumers. Wow.
Thank you, Paul. That concludes our panel discussion. I'll ask all of our panel members at this point to rejoin the audience. And again, I will thank all of our panel members for their participation and thoughtful comments today. Allow me to turn the program back over to Zixta Martinez.
Thank you, Steve. An important part of how the Bureau helps consumer finance markets work across the U.S. is to hear directly from consumers, from industry, from our state and local partners, and from community advocates. One of the ways that the Bureau gathers public feedback is through public events such as these. We have held field hearings, public town halls, and other public events in places such as Indianapolis, Minneapolis, Birmingham, Alabama, Sioux Falls, South Dakota, Durham, North Carolina, Detroit, St. Louis, Missouri, Atlanta, Des Moines, Iowa, Miami, Los Angeles, Itabena, Mississippi, Phoenix, Nashville, New Orleans, Oklahoma City, Oklahoma, Reno, Nevada, El Paso, Texas, and of course now we can add Newark, New Jersey to the list, among others. At these events, we not only hear from experts in the field, we also invite members of the public to participate and share with us their comments. Before I open the floor for your comments, I want to remind folks that there are several other ways that you can communicate your observations, concerns, or complaints to the CFPB. You can file a consumer complaint with the CFPB through our website at consumerfinance.gov. Our website will walk you through the process for filing a consumer complaint about a financial product or service. The CFPB takes complaints about mortgages, car loans or leases, payday loans, student loans, other consumer loans. We take complaints about credit cards, prepaid cards, credit reporting, debt collection, money transfers, bank accounts and services, and other financial services. If you don't have a specific complaint but would like to share your story with us, we have a feature on our website called Tell Us Your Story, where you can tell us your story, good or bad, about your experience with consumer financial products. Your story will help inform the work that we do to protect consumers and create a fairer marketplace. We also have another feature called Ask CFPB, where you can find answers to over 1,000 frequently asked questions about consumer financial issues, as well as additional resources. I encourage you to visit consumerfinance.gov to learn more about the resources and tools the Bureau has developed to help consumers make the best decisions for themselves and for their family. Now it's time to hear from public participants here today. A number of you have signed up to share comments and observations about today's discussion. The open mic portion of the field hearing is also an important opportunity for the CFPB to hear about what's happening in consumer finance markets in your community. Each person who signed up will have 2 minutes to provide public testimony. We will bring a microphone to you. And what we hear from you is invaluable. We want to hear from as many of you as possible, so I encourage you to please observe the 2-minute limit so that everyone who signed up to share testimony today will have the opportunity to do so. And with that, I will call our first member of the public, Beverly Brown Ruja.
Hi, thank you. I just wanted to make a comment on what someone said on the panel, which was that arbitration is so much better for consumers. And if that's true, I'm not sure why it needs to be mandatory. If it is so much better for consumers, I would assume that they would want to elect it, and companies might think about spending their resources educating the public on potential benefits of arbitration rather than making it a hidden mandatory requirement of contracts. Lastly, I just wanted to comment again that if the class action litigation process is broken, we need to fix it. We don't need to create another complicated system that is tilted towards the companies that have so many more resources. And I would say that that's what we ought to be doing rather than creating forced arbitration. That's all.
Thank you, Ms. Ruja. Mitchell Williamson.
It just appeared to me that there was to distinguish between the different types of disputes, and that some may be more appropriate for arbitration, and others may not. I also think that the issue of education is paramount. I think that one thing that we can all agree on is that there isn't sufficient education as to the process and as to the, especially for the consumers. Perhaps if the government stepped in and set additional guidelines for arbitration panels, that would alleviate the problems that were raised by Mr. Bland concerning the national NAF. So I think that might serve some purpose.
Thank you, Mr. Williamson. Bruce Davis. Michelle Schwartz.
Hi, my name is Michelle Schwartz. I'm Director of Justice Programs at Alliance for Justice, and I grew up in nearby Livingston and was Deputy Chief of Staff to Senator Lautenberg, so very happy to be here in Newark with you today. On behalf of AFJ's more than 100 member organizations working for a fair and just society, thank you for conducting this wonderful study. It confirms what we have long suspected, that forced arbitration allows companies to evade accountability when they harm consumers. Our short documentary, Lost in the Fine Print, demonstrates the harm that forced arbitration causes. It tells the story of Debbie Brenner, who was cheated by a for-profit college. When she and her fellow students tried to sue, they were forced into arbitration because of a clause in their enrollment agreement that they never read and certainly didn't understand. Not only did the arbitrator rule for the school, but he also ordered Debbie and her fellow students to pay hundreds of thousands of dollars in the school's legal fees. The film also tells the story of Nicole Mitchell, who's from West New York, New Jersey, and her story is instructive for all who face forced arbitration. The arbitration was secret, she never even got to meet the arbitrator who decided her fate, and she couldn't appeal. Debbie and Nicole, as you point out in your survey, are unusual in that they even made it before an arbitrator. The vast majority of the consumers don't, often because the amount that they could possibly recover is so small compared to the cost of individual arbitration. I've shown our film at national conferences, I've shown it at law schools, I've shown it at tenant association meetings. I always get two reactions. First, people are shocked that they didn't know that this was going on. Second, they want to know what can be done about it. I think that your study will do a great deal to actually educate people about this practice, but much more importantly, you have the power and the obligation to do something, and that is to prohibit forced arbitration in all consumer financial products within your jurisdiction. I hope that you'll do that without delay on behalf of all our members. Thank you.
Thank you, Ms. Schwartz. Harley Schnell.
Hi, I'm Harley Schnall. I'm here as a consumer as well as a consumer attorney. I'm sorry I don't have any prepared remarks, but I can tell you the results of mandatory arbitration from my personal experience. As a consumer attorney, it's been wonderful for the consumers who were smart enough to opt out of their arbitration clause. We've achieved terrific results for the 1 out of 10,000 who thought to look at the fine print and actually opt out. As a consumer, I was subject to a mandatory arbitration clause, no opportunity to opt out, and I actually had I could file an arbitration for no cost under this arbitration clause, which is great. I think if you're looking to make it more convenient for consumers, that's a great practice. Or actually, perhaps limit the fee to a percentage of the claim. Anyway, when I filed with AAA, the defendant refused to pay the fee, and I was told by AAA I could pay the defendant's fee. Eventually, this settled out, and it was wonderful for me, but unfortunately not so good for the no doubt thousands or hundreds of thousands of consumers who were customers of this credit card company that was posting payments days after they received them and had no idea that this was going on. The defendant in this case also wanted the proceeding to be secret, and under the terms of the release, we would not agree to that. So I'm not sharing the name of the creditor today, but that gives you an idea of kind of what goes on. Thank you.
Thank you, Mr. Schnell. Ellen Taverna.
Hello, my name is Ellen Taverna. I'm the legislative director for the National Association of Consumer Advocates. I want to thank the CFPB for hosting this event today. I think it was a tremendous event, and I appreciate all the hard work that went into the very robust and substantive study. I want to congratulate the two NACA members that participated in the hearing. Jane Santonio and Paul Bland are both NACA members, and they represented NACA very well today, and the thousands of consumer protection attorneys that represent consumers across the country. I was fortunate enough to participate in the CFPB hearing last time when the CFPB released their preliminary results. And I was asked the question, what should happen next for the CFPB? And I told them then that there was enough evidence for them to prohibit forced arbitration in financial contracts then. I'm glad, I'm okay with the fact that you didn't take my advice then. But I really want you to know that the 3 years that you took to examine this issue and look at the effect and the impact on consumers that forced arbitration has, that it unequivocally shows that this is not in the best interest for the public, and that consumers need to be protected against forced arbitration, and that the only solution is prohibiting forced arbitration in financial contracts under your jurisdiction. So, thank you.
Thank you, Mr. Verna. Philip Stern.
Thank you. I'm Philip Stern. I am an attorney locally, handling consumer matters. There's two really points I want to quickly make, and it sort of ties into three different people here. First of all, I want to mention Professor Gillis because I'm a Cardozo graduate, Ellen Taverna because I'm a NACA member, but the last thing I want to talk about is what Professor Gillis talked about was the doctrinal aspect of it. I was the attorney in the case of Bach versus Pressler and Pressler, and my adversary is here if he wants to. If we can debate it again, if you'd like, Mitch. But that was a case involved with the Fair Debt Collection Practices Act. Again, the whole idea of common law and developing doctrine. Had that case gone to arbitration, that area of law would not be developed. These areas of law, the society changes and the law changes with it, and there's no opportunity to do that when you force everyone into arbitration. Thank you.
Thank you, Mr. Stern. Christine Hines.
Hi, I'm very happy to be here today. It's just a phenomenal historical day in the world of Public Citizen, a consumer advocacy organization that I work for. Well, the only thing I can think about now is that there's only one way to go from here. I was listening to Paul Bland's comments about the National Arbitration Forum, and that the National Arbitration Forum was accused by the Minnesota Attorney General of fraud, false advertising, and deceptive trade practices. It was advertising as a neutral arbitrator for consumers. It had ties to the debt collection industry. So it was forcing consumers into a forum that was only for business. And I think that with this incredible data-driven, evidence-based report that the CFPB has just released today, if the agency sits on it, if it waits too long to act, we're going to see another NAF. we will see it. So NAF does not conduct consumer arbitrations anymore, and that's very lucky for consumers out there, but we will see another NAF if the agency doesn't act quickly. Thank you.
Thank you, Ms. Hines. Ann Vardaman?
Thank you for holding this hearing and for putting together this great study. Like what Professor Gillis said, I think it really does just reflect common sense. And I think that we have a greater problem here in that people who and consumers who are the victims of fraud, of predatory lending, of discrimination, should not be forced into arbitration hearings where the companies that have done the harm get to choose who the arbitrator is going to be, and they really lose their access to justice. I really look forward to seeing bans on mandatory arbitration in more consumer financial areas, not just mortgages. And thank you so much.
Thank you, Ms. Vardaman. Susan Langman? Joshua Denbo?
Thanks very much. I'm a consumer attorney as well. There was a comment regarding judicial hellholes, and this is a shout out as thanks to the CFPB. I represent several hundred consumers, a lot of them having to do with mortgage foreclosures, not entirely. I've been turning away, I forgot your last name, ma'am, I know it's Jane. I've been turning away cases with arbitration clauses. I've been trying to fit them under the new rules, the new regulatory provisions for TILA, which is obviously only property, and for the FDCPA. It's the only way to get anything done to help these people. But the shout out to the CFPB has to do with the mortgage foreclosure defense, or at least we're trying to do it, and the issue regarding the comment regarding the judicial hellholes. I have a transcript where a judge in New Jersey says fraud is not a defense to a foreclosure. It's been said to me off the record 3 or 4 times in different counties. I have 4 different judges who don't provide discovery or allow discovery to happen in foreclosure cases because the bank has the note and they've got an assignment of mortgage and that's all you need. And what's really turned it for me is the new request for information. I have 5 different files on my desk now in which I have lost note affidavits which have been concealed in discovery or not disclosed in the foreclosure process. Those wouldn't happen. I wouldn't have that. I wouldn't have those tools available to me if not for the CFPB. And that's a really, really, really big deal. So the last point I'd like to make is I'm slightly offended by the issue regarding frivolous litigation, the concerns by the industry. Look, there are problems everywhere. Good people lose cases. Bad people win cases. Bad cases win. I mean, these things happen. But I don't bring frivolous cases. And I'm sure that my other colleagues on our side of the bar, we don't bring frivolous cases. And the idea that we're filing these cases to help people in order to make money on frivolous filings is a little ridiculous. There's not a tremendous amount of money to be made on any one of these cases, and they take a tremendous amount of work and effort and dedication to bring them to fruition. So there are no frivolous cases coming out of my office, and it's a very hard way to make a living, but it's a lot of fun.
Thank you, Mr. Denbo. Joanne Dorshow?
Thank you so much. I'm the executive director of a national consumer rights organization called the Center for Justice and Democracy at New York Law School, and I want to join many others here today in thanking the Bureau for this incredible study. It's such a pleasure to be able to argue this issue based on actual data rather than rhetoric. And I think what the data clearly shows is that arbitration is not a preferable alternative to court, and that what class action waivers do is they make, as Paul Bland says, they make cases disappear. And just to follow up briefly on the class action issue, class actions, I think what this study also shows is that when a company receives a windfall from small injuries to large numbers of people, a class action is the only realistic way that that case can be brought. And the study puts a complete lie to the theory that class actions don't benefit consumers. They benefit consumers tremendously, and then they cause all kinds of important changes in behavior that would not have been possible without the class actions. Our organization did a similar, or not a similar study, but a study on the importance of class actions, and we examined many of the same kinds of settlements that the Bureau did, including the one that Director Cordry mentioned in his opening statement about the overdraft fee cases, tremendous benefits to consumers. And finally, just to join in others who have said, if, despite all this evidence, companies still insist that arbitration, forced arbitration, is better for consumers, well, let consumers choose it post-dispute. And of course, they're never going to do that voluntarily, so we urge and very much hope that the Bureau will take the next step to ban forced arbitration and class action waivers and contracts. Thank you.
Thank you, Ms. Dorshow. Carl Meyer.
Yes, thank you. Carl Mayer, consumer lawyer. I found the hearing today quite illuminating in that the representatives from industry did not take issue with the empirical findings of the Consumer Bureau's report. Rather, they offered anecdotal evidence exclusively as to why these arbitration clauses help consumers. But I thought the representatives, and I want to enter this into the record, I thought the representatives from industry in offering anecdotal points actually stated some facts that aren't the case in my experience as a consumer advocate and in litigating these cases. The first claim was made by, I think, Mr. Lipinski, that a loss, that only an arbitration setting is a setting where you can sit across from the other party and try to negotiate a solution. Well, actually, in New Jersey, there's a mandatory mediation that goes along with litigation, so that if you bring a litigation, you wind up sitting down with the other side actually often earlier. The second point that I think was inaccurate is that the claim that was made that arbitration is less costly than the class actions. For the consumer, that's not accurate either, because the consumer has to pay the out-of-pocket costs of the arbitration, which often can be not a couple $100 over to $1,000. And in addition, they have to pay their attorneys. In a class action setting, there are no out-of-pocket costs to the consumers. The risk is all on the consumer attorneys who take it on a contingency. So the other point I'd like to make that I think is just not accurate, and no one cited a study for the proposition that Mr. Lipinski and the other industry advocates made. They made the proposition that a lot of consumer complaints, or the majority of consumer complaints, are resolved within the company before they ever reach litigation or arbitration. There was no citation for that. And in all my experience, it is more and more impossible for consumers to resolve these complaints, because you have the offshoring of these call centers. You have wholesale companies, large companies like Verizon or American Express. They've eliminated their executive offices, so there's no way to escalate a claim. You can't even get a person on the phone. And often, the people who receive these calls in real life, they're instructed not to give the name or the phone number of their supervisor, and are told, we'll give you a call back, which never comes. So I would encourage the Bureau to follow up on the industry's anecdotal claims and look at the culture of consumer complaints and resolutions in addition to their empirical work.
Thank you, Mr. Mayor. David Hungerford. Alexander Schmid.
Hello, I'm a plaintiff's class action lawyer. I'm a partner in the law firm Wolf, Haldenstein, Adler, Freeman, and Hers in New York. I've been practicing law for about 30 years. We've heard a little bit mentioned today about the right of access to the courts and the right to sue in court. I'd like to just expound a little bit on the legal framework of that right, and there really is a constitutional dimension to it that is not often mentioned in the discussion, and I just would like to elaborate on that. It's not just the Seventh Amendment jury trial right that we're talking about. There is a fundamental First Amendment right to sue in a government court. And I'll demonstrate that by reading a few quotes to you. The petition clause of the First Amendment says, Congress shall make no law abridging the right to petition the government for a redress of grievances. In a series of cases between 1972 and 2011, the Supreme Court unequivocally held that the First Amendment rights protected by the petition clause include the right to access to the court. In 2011, a seven-justice majority of the court, 2 months after the Concepcion decision, stated that the petition clause protects the right of individuals to appeal to courts and other forums established by the government for resolution of legal disputes. And in 1945, and since 1945, it's been very clear that the right of petition is inseparable from the freedoms of speech, press, and assembly, and is one of the four cognate rights united in the First Amendment's assurance. So in other words, the right to access court is just as sacrosanct as the right of freedom of speech, the right of freedom of religion. And let me just read you one more quote, and that is, what does it mean under the petition clause to have to seek a redress of grievances in court? You go to the dictionary definition, and the definition of redress is the setting right of what is wrong, relief from wrong or injury, compensation or satisfaction for a wrong or injury. So there's a fundamental First Amendment right to get relief on the merits from a government court. And I would wonder what the public debate would be like and what the Bureau's decision would be if what we were talking about here was financial institutions through form contracts limiting the rights of free speech or limiting the rights of consumers to practice their religion. We're talking about something from a constitutional dimension that's equally as important, and that is, should there be a mandatory forced abdication of the First Amendment right to get relief from a government court? And I hope that you consider that. Thanks.
Hugh Campbell.
Thank you for the opportunity to comment. I'm a certified financial crime specialist as well as a CPA. And I find a bit of hypocrisy with industry that at every turn they sing the praises of the free markets. But in this instance, they have no problem taking away people's rights without direct compensation. And then hitchhiking the ability to suppress class action suits. In Thomas Paine's famous pamphlet that inspired the American Revolution, he said the purpose of government was to protect the people from vices. And I believe it's a vice to take away these rights. Also, you find the situation, I'm sorry, I lost my train of thought, but, many people might realize that there's a fraud triangle, but on two sides of the triangle are only under the control of the fraudster, namely perception of incentive and perception of rationalization. The other side of the triangle is opportunity, and it's up to the government to prevent the vices by taking away the opportunity.
Thank you, Mr. Campbell. Stephen Denetis.
Thank you. First, I would like to thank the CFPB for this great study. It is extremely important to consumers. I am a class action attorney representing consumers for more than 17 years. And since the Supreme Court's decision in AT&T Concepcion, the practical effect of that decision has just foreclosed cases. Consumers seek out someone like me when they're mad and frustrated. They're mad and frustrated because they have a small amount that's in dispute. Could be a $100 alleged illegal fee. It could be a $2,000 stucco problem. It could be a $200 defective battery on their computer, and they call the company and they don't get redress. They then go to attorneys who don't handle class actions, and those attorneys tell them, well, look, the amount in dispute is really not worth it for me to handle your case because you'd be throwing good money after bad because I can't do it on a contingent basis because there's not enough money, and to pay me hourly, you might as well just forget about it. So those people seek me out. And since AT&T Concepcion has come down from the Supreme Court, the first question I ask in practice now, when a person has a dispute, is, do you have a contract with the company? The reason being is, if that contract has a class action waiver provision, our firm just turns the case down. And I'm seeing more and more cases, because now companies, now it's been 4 years since AT&T Concepcion, more and more general counsel, more and more companies are getting smart because it's a way of insulating liability. Even when it's a clear-cut statutory violation, a clear-cut product defect, a clear-cut illegal fee, it doesn't matter. Because if that company has a class action waiver provision in their arbitration clause, there's no use of us fighting because we can't defeat it. An example, a gentleman came into my office with Lenovo computer, had a defective, what he alleged to be a defective battery, had documented emails and 4 calls with the company asking for it to be replaced. They said there was no problem with his battery. They weren't willing to address his concerns. He wanted to do something about it. Came into my office, and lo and behold, there was a class action waiver. I could go on a litany of companies, Orleans Home Builders, Bank of America, Nissan Credit Services, cell phone companies. The one criticism I have of the CFPB is it doesn't go far enough, because this is something that transcends all industries. And it's getting to the point where the pendulum has swung, where people can't get redress. And people oftentimes criticize and say, well, you know, the only people who benefit from a class action are the attorneys, but they don't understand class actions. Because the idea of a class action is when there's an amount in dispute that's so small that they can't go and get an attorney on their own because it's just not practical. And being able to put those people in a class with small claims gives them the power to fight the big company. So I commend the CFPB for for doing this study. I urge them to push, to set forth to ban mandatory arbitration clauses. And as people have said here, I have gone to arbitration.
Thank you, Mr. Donetis.
Thank you.
Appreciate your comments. Matthew McGinley. Gladys Pera. David McMillan.
Hi, my name is David McMillan. I'm an attorney at Legal Services of New Jersey. We're the statewide office for the legal services system. On behalf of our low-income clients, I wanted to make a couple of quick points. First, in response to the point about small claims court, one of the serious problems there is that discovery in small claims court is generally not available or extremely limited. Here in New Jersey, you get 5 interrogatories without subparts. Period, that's it. In most consumer cases, the company has the vast majority of the information that's relevant to proving the case. So without discovery, it's not much of an alternative. People have mentioned class actions here. There are a couple of excellent examples from the New Jersey Supreme Court, both decided circa 2006, and that date is significant, Both involved class actions based on New Jersey's usury laws. Both were successful. Muhammad versus County Bank was an internet payday loan case. Perez versus Rent-A-Center was a case applying New Jersey's usury laws to rent-to-own transactions. What happened to those cases? Muhammad was reversed by the Concepcion decision. It was one of the state court's decisions that was reversed. Class decertified. All of the class members could no longer get relief, and frankly, the plaintiff in that case had a viable case because there was a potential for class action. Without the potential for class action, someone in the same circumstances today would have little chance of getting a lawyer. If they came to legal services, we would do everything we could to help them, but they're very difficult cases. If we can get someone a lawyer who can work really hard, and it's harder because of arbitration clauses, we can help them. But by and large, it's very difficult to find assistance. Perez versus Rent-A-Center, at the end of the day, $80 million approximately went out in checks to New Jersey low-income consumers. Today, we wouldn't see that case happen because the defendant in that case, what did it do as a result? It adopted an arbitration clause. Final point, really quickly, I've alluded to it before. In addition to the class action problems, the practical problems facing consumers because of arbitration clauses are very palpable and make a huge difference. Cost is first and foremost among them. We've heard some information about that. One of the panelists mentioned that, oh, well, you can pay a nominal filing fee to get your arbitration heard. The absolute best case scenario is AAA, $200 filing fee. I looked through the rules for how do you get a waiver of the $200 filing fee. There's nothing in there unless you're from California. Now, $200, I don't know. For some people, it might be what you spend on lunch. Our clients are faced with the decision of whether to heat or eat. $200 is not an option. Without the waiver of with the fee there, with any risk of having to pay fees at that level or more, arbitration is not an alternative that we can recommend to somebody. It could be ruinous. Arbitration is plain and simple, far more expensive than court, and that makes a big difference to our clients. So we urge the Bureau to, plain and simple, ban mandatory arbitration clauses. If arbitration is useful, consumers can choose it along with businesses after a dispute has arisen. Thank you.
Millen. And thank you to all that provided thoughtful comments here today. Thank you to the audience, thank you to our panelists, and thank you to all those watching via live stream at consumerfinance.gov. That concludes the CFPB's field hearing in Newark, New Jersey at Essex County College. Have a terrific afternoon.